Is liberty dying where you live? Escape to Keene at freekeene.com.
President Hall, if you would fill out a card.
Head your way.
This one doesn't.
Chairman Rowe, members of the committee, Representative Holt, Merrimack 23. The bill before you is a very simple piece of legislation, and it's due to the Supreme Court ruling that came out this past fall. Copies have been sent to you, I believe, already on the Rich Ball piece. The Supreme Court, in its interpretation of the current statute, said, and I paraphrase, but if the legislature had decided this, meaning the text that was submitted in 2012, and not the text that was passed, we would tell you that you have jury nullification. But because you don't, the jury does not have the authority to judge the application of the law. So what this bill is the version that was submitted the first time that was then modified along the way. That's all it is. This House has passed before this bill. It was modified along the way. All I'm doing is re-entering the same bill that was passed the first time, or was submitted the first time, to reconsider it if we want to have what is known as jury nullification, or the ability of the jury to weigh in not only on the facts, but the application of the facts of the law. Then we need to pass this language according to our Supreme Court.
The bill we passed last year was the Wentworth instructions, but we also allowed the defendant, in the defendant's closing argument, to give additional information regarding the Wentworth instruction, the right of the jury to judge the facts and apply the law or not apply the law to that particular case. And this decision doesn't change that at all.
It is, not to get into a debate, but it is not. It is the opinion of the Fully Informed Jury Association and many others that have looked at this and have weighed in on the Supreme Court's ruling that the Supreme Court looked at the history of the legislation and then said, had you passed the language as submitted, we would agree with you that you would actually have the ability for the jury to judge not only the law, but the application in that case. But because this is not the language that was submitted and I pulled it right out of their brief, and that was the language that was filed in 2012, you do not have the authority to judge all of that. And that was their opinion in the Rich Ball case. So I would ask that we take a look at this and pass this legislation if we want to allow the jury to weigh in on both the facts as well as the application of the facts. We need to change the current statute.
Will you answer any questions?
Absolutely.
Yes, Representative Woodbury.
Thank you, Mr. Chairman. Thank you, Representative Cole. I'm curious about the language that appears on lines 4 and 5.
Okay.
Giving a jury a right to nullify any and all actions it finds to be unjust. And my question is, what standard does the jury have other than its own feeling? Its own intuitive feeling about what might be unjust.
Well, and therein lies the benefit, right? The jury can use their own conscience, right? Well, it depends how you say it, I guess, right? The jury can use their own conscience. We can, as a legislature, put in overly harsh penalties, okay? When you use the fact that it's currently a misdemeanor to give a haircut. Okay, it's a felony to set up a business for the purpose of cutting haircuts and not registering or getting licensed by the state. That if some hairstylist was charged with that felony, it may make sense for the jury to weigh in, that there is adequate proof that the defendant was actually cutting hair, and there was adequate proof presented by the prosecution that the person was running it as a business, and the person actually has receipts and shows that they paid taxes, but they failed to get the appropriate licensing, and therefore We find them guilty of the charge in terms of the felony, but we're going to toss the case out because that was clearly an overstep of the legislature. The entire intention of the jury was to act as a safety valve, per se, for legislators that had gone awry.
Representative Kennison?
Thank you very much, Mr. Chairman. Now, under this, I think what you're saying is the jury has an inherent right to judge the law, which is the jury could say, I don't like this law, therefore the facts don't apply. This goes way beyond that to say, okay, we don't like this law you passed, legislature, and we're going to find not guilty based on we don't like your law. Is that correct?
That is correct, and that was that. If you look at the history of the jury and why it was such an important thing, and I would encourage all of you to read a book called The Citizen Rule Book, which talks about juries have authority that even the President of the United States doesn't have, because they can, in fact, weigh in on a case and find the defendant, okay, guilty of the charge, but acquit him, okay, because they don't believe the law was just, okay? That's something that was intended to be part of our jury, our criminal justice system, for the sole purpose of making sure, back to, you were cutting hair for a business. You traded eggs for your neighbor's haircut, or the ability to cut your neighbor's hair, right? And now you're in the business of cutting hair, and you've been charged with a felony. Clearly, I don't think anybody in this room would argue that that is a suitable punishment for the purpose of cutting hair. But that's what our law says.
Now, RSA 519:23A, right of the accused, which is our law today, it says, in all criminal proceedings, the court shall permit the defense to inform the jury of its right to judge the facts and the application of the law in relationship to the facts in the controversy. Isn't this exactly what you're asking for?
Thank you, Chairman Rowe. So this is a repeal and reenactment of that particular statute.
Why would we want to reenact what is law to do what you want to do, except for a little difference in wording?
Great question, because I happen to have a difference of opinion of the Supreme Court justices of the state of New Hampshire, and since they have weighed in on what this language says and what this language does and does not do, I am deferring to their opinion in the case of June 18th, 2014, where they say, in fact, that had the language been this words instead, we would have jury nullification, but because we didn't have that, we're going to weigh in differently on the case.
Do you agree with, is your interpretation of jury nullification the same as mine? That the jury has the right to judge the facts and the application of law in relation to the facts in that particular controversy?
Yes. And they and one step further, and they have the ability to choose not to prosecute that person under that law, given that evidence.
But that's what the law says. That's in the books that we passed last term.
If I may, I believe that was 2012.
2000 went into effect January 1st, 2013.
Yes. Okay. So we're talking about the same law. Okay. And I would encourage you to read in full, and I can submit this as evidence or as written testimony. The State of New Hampshire versus Richard Paul, opinion issued on October 24th, 2014.
I've read it. The committee has a copy of it.
Okay. And there, after a long discussion, they go in and say, they start on page 4, okay? In 2012, and I quote, the New Hampshire legislature enacted RSA 519:23A, which took effect on January 1st, 2013. It states, in all criminal proceedings, the court shall permit the defense to inform the jury of its right to judge the facts and the application of the law in relation to the facts in controversy. It then goes on as a discussion about what the language was and what it ended up. And it strikes the ability, it overrules the lower court's decision. And that's why I think we have to make the change. The New Hampshire Supreme Court told us so.
Thank you. Representative Birch.
Thank you, Mr. Chair, and understanding that we're here not to debate, but to seek information from the witness. Let me ask you, based upon... It wasn't that wasn't a comment on you, Mr. Chair. It's just, I would have a lot to debate if I were in the mood to debate, from the history onward. But my question is more fundamental on your bill, which, as I understand it, would grant the jury the right to ignore law in the context of its decision. And my question is, if a jury decided it wanted to ignore the presumption of innocence and the requirement that the state prove a case beyond a reasonable doubt, which under jury nullification a jury could do, so that if the judge says to find someone guilty of burglary, the state has to prove 5 things, and the juror believes the state has only proven 4, does your bill suggest a jury has a right to find someone guilty even though the state has not proven its case by the process of jury nullification?
It's a good question. I haven't thought about that. The way I see jury nullification, thank you. My understanding is this would be something where the defense would be using it, but it is arguable the prosecution could also use it. I don't see that happening, so I'm not sure whether we're chasing a little bit of a red herring. In general, the burden is with the state to prove their case, okay? Whether they were able to prove 4 of the 5 things or all 5 of the 5 things to charge someone with burglary, okay? The burden is on the state. If they cannot prove that, the defendant should be let go.
So, in the process of selecting a jury, when one of either the prosecutor or defense counsel says, do you believe the defendant sitting right there is guilty? And the potential juror says yes. I gather there's no impediment then to putting that juror on the jury, because that juror has a right to ignore the presumption of innocence.
I haven't sat through that. Thank you for the question. I haven't sat through that many jury trials when it comes to criminal defense, but I would argue that likely the defense attorney would ask to have that juror removed from the jury pool because of that presumption.
Yes, Representative.
Thank you, Mr. Chairman. Isn't it true that under the Wentworth decision, it said the jury's instructed that they must find the person guilty? I'm screwing up the words here, but they must find the person guilty beyond a reasonable doubt. And then it goes on to, and they should, or I forget what the word is, find them in a...
They should find them not, they must find them not guilty.
I don't have it in front of me.
They haven't proven it.
Yes, but it's beyond a reasonable...
There it is.
Here it is. Beyond a reasonable doubt is already in the Wentworth decision, which would eliminate the possibility of the jury using it to convict somebody that is not, they're not convinced is guilty. Isn't that true?
Okay. I believe, if I understood your question correctly, yes, the jury would not be able to find someone guilty that hasn't met that threshold. In full disclosure, I have not read the whole Wentworth decision. I probably should take that as homework out of this. I have read the Rich Paul case, and it was only because that came up during the filing period and was clear that the Supreme Court has instructed us, basically, if you want this, then this is the word you need to use, meaning this being jury nullification, then I would heed to their opinion, as they are clearly more scholarly than I, and I would go ahead and put that in statute if that's what we want to do. And that's all this is doing, is asking to put into statute what the Supreme Court told us in the October decision would have to be in statute if we wanted jury nullification.
I have one quick.
Representative Lott?
Thank you, Mr. Chairman. Thanks for coming.
Yep.
We had heard testimony on this previously by defense attorney who said, I don't necessarily like having jury instructions to the jury that would be nullification in a lot of my cases. In this particular bill, that takes away the defense attorney's right because it says the court shall instruct. So in the situation where a defense attorney does not choose to have a jury nullification charge, he would be out of luck.
Okay.
Is that right?
As it is written, I personally would be okay if we modified that and said the court shall allow the defense to instruct. Okay, which, although a minor tweak, the important part is actually lines 4 and 5 and 6, not necessarily line 3. So I don't think that fundamentally changes the bill, and nor do I think the Supreme Court would rule that allowing the defense to explain this right is different than the court explaining this right.
Thank you, Mr. Chairman. Thank you, Representative, for taking my question.
You're sure this is, we're not just getting into a debate on this?
Yes,
We
sir.
have a number of other witnesses.
Yes, sir. If I'm understanding correctly, the intent of this bill is to insert into our judicial proceedings an element of justice that you seem to now think is missing or trumped by legalism. Would that be right?
I would restate what you just said, if I may. It would allow for the ability for the people as a whole, in this case represented through the jury, to weigh in on whether, in this particular case, not as a whole, but in this particular case, the application of that law is just, even if there is sufficient evidence to charge the defendant with the crime. And this goes back to, there may be overreaches of our legislation such that you could find the person guilty of cutting hair, and you could find the person guilty of taking money for it, but you would not necessarily want to charge them with a felony.
Thank you. Attorney Chris Keating of the Judicial Council has asked contributors he's in opposition to the bill.
Thank you, Mr. Chairman, and members of the committee. Mr. Chairman, may I leave my visual aid up here because it talks about the Wentworth instruction?
I think it's appropriate.
All right, thank you, sir, and I apologize, Representative Simpson, Representative Wheeler. So I'm Chris Keating, the Executive Director of the New Hampshire Judicial Council. The Judicial Council is charged by statute with providing recommendations to the General Court and to the judicial branch about how to improve the justice system. The Judicial Council voted to take positions with respect to only 7 pieces of legislation this year. This is one of them. I'll speak very briefly because I know you have a lot on your table this afternoon, so I want to say 4 things. 1, we have in the law the concept of jury nullification. It is contained within the Wentworth instruction, which is read in every criminal case by the judge to the jury. And a defense attorney is free to exercise his or her professional judgment to elaborate on that right in closing, to explain to a jury the fact that if the state has failed to prove each and every element beyond a reasonable doubt, then the jury is obliged to acquit the defendant. The court also instructs the jury that if the state has proven each and every element of the offense beyond a reasonable doubt, then the jury should convict the defendant. And so that difference, must acquit if there's been a failure of proof by the state, should convict if there has been proof of each and every element of the offense, contains within it the seed of this concept of a jury's power to exercise its discretion to acquit a defendant even though the state has proven each and every element beyond a reasonable doubt. So we have it. There's nothing that needs to be added to augment that right. So that's one thing I wanted to say. The second thing I wanted to point out, and I say this very respectfully to the sponsors and to the members of this committee, I have a hard time understanding why a legislature and a legislative body that works so hard and puts so much time in and spends so much of its valuable days debating legislation would be so contemptuous of its responsibility and obligation and prerogative to say what the laws are that govern us all. That you would say to juries, don't pay any attention to what we've decided ought to be the law. You can decide for yourself. That doesn't match with the amount of effort and time and energy and responsibility that you have to do your work. 3, this concept of shall instruct a jury on nullification can really, I think, undermine people's respect for the criminal justice system. Can you imagine in a child sexual assault case, if a judge were instructing the jury, hey, you don't have to follow the law if you don't think that this sort of thing should be against the law. I think juries like to know that child sexual assault is against the law and that the law prohibits engaging in that conduct, whatever an individual juror might think about the propriety of child sexual assault. The last thing I want to say is this bill is very, very dangerous. I think it's a beguiling concept to empower juries broadly to decide the law in addition to their responsibility to decide what the facts are. But as someone who spent 20 years as a criminal defense attorney, I've tried over 30 cases myself, including first-degree murder, and I've supervised the public defender program for 12 years and supervised a lot of lawyers handling jury trials in the criminal justice system. Criminal defendants are protected by the law. The law includes the presumption of innocence. The law includes the obligation of the state to prove each and every element beyond a reasonable doubt. The law includes the rules of evidence, which are the rules that protect the fairness of jury trials. The law protects criminal defendants. A law that encourages juries to ignore the law, I think, is dangerous to criminal defendants who would be subject to the whims and individual prejudices of jurors who sat on their cases. I'll take any questions. That's the conclusion of my remarks. Thank you.
Thank you, Mr. Chairman. You brought up sexual assault. I've lost track of where this was, but I know years ago we tried to fix this, but there was a time when if a 15-year-old girl went out with like a 17-year-old boy and was prosecuted, that boy would have to register as a sex offender for the rest of their lives. Wouldn't jury nullification allow a jury to look at that and say that's ridiculous? He's not a sexual predator, he's a teenage boy. Wouldn't the application of something like this be the perfect situation where jury nullification can work, where you really shouldn't apply the law as it's written?
Thank you for the question, Representative Hopper. 2 points. I don't have the statute in front of me, but I think the person in that incident would not be a Tier 3 offender who would have to register for life, just parenthetically noting that. But I think cases like that one are the kinds of circumstances, depending on what the testimony might be, when a defense attorney might elect to elaborate on the Wentworth instruction in their closing to remind the jury of this right that is enshrined already in the law to not convict a defendant even though the state had proven each and every element beyond a reasonable doubt. So I really only want to reiterate that the law as it exists contains this concept and this right of juries to acquit even though the state's proven each and every element beyond a reasonable doubt. So you don't need this very, very broad and dangerous piece of legislation to augment that.
You seem to be, in my simple mind, arguing over two phrases. One, application of the law, which is in our statute, and in this bill it says nullify the law. In my opinion, the jury doesn't nullify the law, but the application of the law to the case. Are we talking about the same thing? Except one is more promotes.
Well, thank you, Mr. Chairman. These concepts of nullify aren't defined in the statute or really in the law, so I'm not quite sure I'm in the position to answer your question about what it means.
Thank you.
Thank you, Mr. Chairman.
Thank you very much.
May I leave my visual aid in place? Thank you.
Howard Zibel, he represents the judicial branch. He has the 3 minutes and he opposes the bill. Good afternoon.
Good afternoon, if I may again. Mr. Chair, assuming it's okay? I know you may have this, but I thought for these purposes it would be good to pass out. Howard Zibel, General Counsel to the Supreme Court and the Judicial Branch. I've passed out the State v. Paul case decided October 24th. And I have to say that Judge Lynn must have spent his fall anticipating the issues that would come before this committee on February 17th, because he wrote 2 decisions right on point with the issues the committee is dealing with. One of the issues I think just arose in the chair's question is that there is no universal definition of what is jury nullification. It's clearly the power of the jury to acquit when all the facts are there to convict. But beyond that, there's no single definition. The Wentworth instruction below me is New Hampshire's iteration, the difference between must and should. And as Attorney Keating said, counsel for the defendant is free to argue to the jury and tell the jury what they're going to hear from the judge. And you're going to hear this must acquit, you're going to hear this should convict. I've talked to judges, I said, would you bar that argument in any case? And they said no. Now, there are some cases that a defendant doesn't want to go there, but a defense attorney is free to make that argument. The problem with this bill is that it defines jury nullification, in essence, in the inherent right of the jury to judge the law. And in the Paul case, and I referred to this last time I testified on this, and I said that bill didn't raise the question. This bill would raise the question. I don't have an answer, but the court may have signaled an answer, but they weren't faced with the question. In the Paul case, starting at the bottom of page 5 to the middle of page 6, they have a paragraph where they cite 2 1800s cases. And at the end of that paragraph, in citing a case from 1869, they noted that in an earlier case, Pierce, which was I think 1842, in Pierce, the common law of New Hampshire, which prior to that decision had permitted the jury to judge the law, quote, was held to be illegal and unconstitutional. And the new doctrine was announced that the jury are not the judges of the law in criminal cases. In 2015, well, this would take effect upon passage, so in 2015, is it constitutional to allow the jury to judge the law? I don't know. Only my bosses can answer that question. But citing some case law from the 1800s, citing it in 2014, calling into question the jury's power to judge the law as to whether it's constitutional, to me, may signal an answer. But I can't definitively say that that is the case. So if you pass this, you would clearly raise the question, and it'll get up to my bosses, and they would have to make a decision to whether it's constitutional to have the jury judge the law. I think there's some good reasons that you don't want to do that. Besides the ones mentioned by Attorney Keegan, you spend a lot of time and take this $100 a year job very seriously in enacting our laws. The citizens send you here for that exorbitant sum, and you spend a lot of time considering, and I watch executive sessions, and you discuss the bills, you discuss it intelligently. The citizens entrust you to make the laws. I don't know if we want to turn our trials into legislative hearings, because if the jury has the inherent power to judge the law, that means experts could be brought in a case to talk about the law. Every case could become a legislative hearing, only for the individual case. But if the law is going to be judged, both sides could bring in experts to talk about the law. To me, that doesn't make a lot of sense and undermines your role, which is an incredibly important role in our society. And in the 15 years I've been doing this work, it's frankly been a pleasure to watch you folks do it and how seriously you take that one.
Attorney Ziegler, will you answer any questions?
Of course.
Are there any questions for Attorney Ziegler? Yes, Representative Hopkins.
Thank you, Mr. Chairman. But you don't find, you do believe that the jury has the right, the inherent right of whether or not to apply the law.
They have the inherent right to acquit, even though all the facts point to guilt.
Thank you.
Right there.
Thank you very much. I have a card from Chris Cantwell.
That'll be me.
And you've asked, you support the bill, and you've asked for 5 minutes?
Yeah, I'd probably be less than that, actually. I think you've all brought up some good points here. Somebody had asked the question of, if you will, reverse jury nullification, where a jury may find a person guilty even when the state hasn't proved their case. I think that actually happened in the Rich Paul case. He was found to have sold, the state's own expert came up and said that what he had delivered to the informant was something called 2CI, which was at the time legal. The state's own expert came in and said that. Rich had never said he was selling LSD, but yet the jury found him guilty of that charge anyway, and I thought that that was rather abhorrent. So this is actually already happening, even without this law being passed, but we are supposed to have a protection against that, actually, which is that the judges do have the authority to dismiss a charge at any time during the course of a case, is my understanding. I wish they would use it more frequently, but my understanding is that they do have that authority. What I see as a difference between this bill and what's on the books already is that the court is mandated to instruct the jury, whereas right now only the defense is able to bring that up. The jury is necessarily going to see the judge as a higher authority than a defense attorney, or in the case of a pro se defense, the defendant himself. If the defendant comes up and just says, please don't find me guilty because the law sucks, that's a lot different than if a judge tells them that they have the authority, the legal authority to do that. The judge telling a jury that they should convict, in their minds, is just as good as saying must. This notion that an authority figure with the power to put people in prison is just making a polite suggestion. I mean, I just don't think that that's worth taking seriously. I know people in this state who have been prosecuted for the heinous crime of disobeying a police officer. That a police officer tells you to do something, there's no law that it says you have to do, but a police officer tells you, do this, and you don't, and then you go to jail for disobeying a police officer. So the notion that a judge is just making a polite suggestion, I just think that's crazy. And I do believe that this, adding this language is necessary. The one thing I would say, though, is I don't know if I'm pronouncing your name right, Rep. Roulard. I think you brought up an interesting point, that saying that the judge shall, as in the judge must, even if the defense doesn't want it. I do think that that's a very good point, worth taking into consideration. That might be worthy of taking into consideration the language of the bill. But all in all, I do support HB 470. I think it ought to pass, and I thank you for your time, and I'll be happy to answer any questions.
Are there any questions? There appear to be none.
Thank you very much.
The last card, Elizabeth.
Woodcock. Woodcock, sir.
How do you pronounce your name?
Woodcock. It's like the American woodcock that people shoot every fall.
Thank you. I couldn't get that from your spelling, your writing. And you represent the New Hampshire Department of Justice. You oppose the bill. You've got written testimony, and you've asked for 2 minutes.
Correct. And I don't want to repeat the information that you've heard from Mr. Keating and Mr. Zibble. Although the written testimony that I have would sort of cover that, I wanted to give the committee a chance to kind of take a look at the actual language of the bill, and also to put it in the context of a trial. The language, first of all, starts off and it says, in all court proceedings. So presumably this applies to civil and criminal proceedings. And that's something that the legislature might want to really think about, because that would mean that really virtually all of your laws would be subject to nullification. The language then goes on and it says, in all court proceedings, the court shall instruct the jury of its inherent right to judge the law as well as the facts, and to nullify any and all actions it finds to be unjust. I've tried to think of a way that this might, I can see how this would work to the detriment of a prosecution, because frequently, I mean, jurors do not like the case that is presented to them, or not frequently, but they do sometimes in a criminal prosecution. And there are situations in which they will tell the prosecutor afterwards they had essentially not liked the case and not liked the way that the case fit with the law, and applied the law and the facts and decided against the state, even though the record would suggest that the state's case was pretty strong. But if the jury has essentially the right to ignore any of the laws, it has the right to ignore all kinds of presumptions, not just the presumption of innocence. There have been times in this country when people who belonged to an unpopular class of people, and we don't have to think very far back, for some of us it's happened in our lifetime, those people were subjected to very unfair trials, were found guilty, and for no real other reason than the jury had a prejudice against that person's background. It could happen at any time. It could happen to any one of us. So that when you're saying that the jury can decide that it can just decide to ignore any law it finds unjust, that law might be a presumption of innocence for a person who comes from an unpopular minority. In that regard, I think you have to ask yourself, what would it do to a defendant's appeal? If the jury has the right to ignore the laws it finds unjust, what does the Supreme Court do if the jury has found somebody guilty on insufficient evidence? Because the statute says you have the right to ignore these laws. And so what does the Supreme Court do? Now, one would presume that the Supreme Court would enforce the defendant's constitutional right to be found guilty on facts sufficient to support that finding of guilt. But it's still not clear from this legislation. One thing that I wanted to point out to you, and it's not something that everyone is familiar with, but in a criminal case in New Hampshire, at the close of the case, when people are giving closing arguments, the defense goes first. And after that, the state can get up and the state can respond to things that it feels the defense has raised. If the defense stands up and begins to argue jury nullification, that may open the door to the case being reopened so that the state can add additional information which would not be ordinarily admissible. It might give the state the opportunity to strike harder blows in its closing argument than normally would be appropriate. New Hampshire, I have tried several cases in New Hampshire, and I've been a lawyer here for a little over 6 years. I've practiced law for 26, and I've been a prosecutor for 24. And I'll tell you, having worked in 4 different jurisdictions, New Hampshire's trials are noted by the fact that the lawyers who present the cases to the jury are both gentlemen and gentle ladies. They're polite. They try to follow the law. They try to present a case that is persuasive on both sides to the jury. And I fear that in this particular case, if you begin to open up this area, you would also be opening up a trial to low blows and unfair argument that is made fair simply because the gates have been opened. So I'm willing to submit my written testimony. If anyone has any questions, I would certainly attempt to answer them.
Yes, Representative Soka.
Thank you, Mr. Chairman. Would you say that this body, the legislature, and the courts have a higher authority than the people of the state?
No, a different responsibility. But sir, you have to understand that the concept of jury nullification is nothing new. In my written remarks, I quote an opinion from Justice Oliver Wendell Holmes, Jr., who talked about jury nullification in 1920. It's something that jurors, even if they don't call it jury nullification, if they look at a case and they feel that the facts and the law don't merit a conviction, they are not just willing, they feel obligated to return a verdict of not guilty. And I think that the instruction that they're given by the court under the Wentworth decision is an instruction that is appropriate. But no, I wouldn't say that anyone is more important. Your role is a different role. It's a role to try to determine what the needs are of the public and what best responds to those needs. And I am suggesting to you that in my opinion, in the opinion of the New Hampshire Attorney General's office, this bill doesn't do it.
Thank you very much. I have one last, in fact, I have 2 cards from the same gentleman. Ian Fleming.
Freeman, I apologize. I put in the second one after you said you were on your last card, so I didn't realize.
And you support the bill?
I do.
You asked for 4 minutes. Can you squeeze it down to 2 or 3?
I'll do my best. My name's Ian Freeman. I'm one of the chair of the board of directors of nhjury.com. It's an organization that is devoted to educating both jurors and potential jurors as well as legislators on the issue of jury nullification. I have personal experience with the Rich Paul trial. I was there filming that trial as it happened, and I helped fund the appeal to the Supreme Court on that. During Rich Paul's trial, he actually requested for a different jury instruction than Wentworth to be given. Now, I don't know how many of you are familiar with the case of Doug Darrell. He is a New Hampshire resident who was on trial for growing some marijuana. He was found not guilty by way of jury nullification. There was one juror on his jury pool who knew about jury nullification, and she flipped every other juror on that jury pool by explaining to them that they had the right to judge the law itself. And during the Doug Darrell case, the judge in that case, this is from, I believe, the union leader, they actually quoted the instruction that he gave. I'm going to share it with you because I think it's excellent in comparison to Wentworth, which I think is deficient. But the instruction from Judge James O'Neill was the following, quote, "Even if you find that the state has proven each and every element of the offense charged beyond a reasonable doubt, you may still find the defendant not guilty if you have a conscientious feeling that a not guilty verdict would be a fair result in this case." That makes it very clear to the jurors that they have the right to nullify the law. The Wentworth instruction makes it very blurry, especially when you get a judge like happened in the Rich Paul case who rejected the other judge's instructions. And Rich Paul's judge made sure, even after the defense attorney had talked about jury nullification in her closing argument, The judge made sure to emphasize certain words during his jury instructions. He said things like, you have to judge the law as I instruct you, and would put a lot of emphasis on the words I to make it really seem to the jury like, well, whatever the defense attorney said is just not an issue. You should just ignore whatever the defense attorney said and listen to me. I'm the man in the robe. I'm the one sitting up higher than everyone else in the room. And this was the attitude of that judge. And the jury found Rich guilty. After the trial was over, I was outside the courthouse when the jurors were coming out with my video camera, and I wanted to interview the jurors as to why they made the choice they did. When they had been given the information about jury nullification, why did they decide to not nullify? And one of the jurors revealed to me that they felt as though they would be breaking the law if they were to find him not guilty. So I think that the way the judge presented the instructions in that case really kind of poisoned the jury on the idea of jury nullification. So I think that the court should be explaining this right. The amendment that Ms. Rilliard proposed earlier, I don't think should be accepted because if the court isn't instructed to explain what jury nullification is, then many of these judges will do everything they can to try to obscure the concept. And no surprise, you've got people who represent the justice system here who are against jury nullification. And that's because they know that it takes power out of the hands of their system. It takes power out of the hands of the judges and ensures that the juries know that they have this power. And none of them have denied that jury nullification is a right of the jury. It's a Magna Carta kind of right. This has been around for a long time. All this bill proposes to do is to simply inform them of that right. It doesn't encourage them to exercise it.
Will you answer any questions?
Certainly.
Mr. Corrigan, a very quick question.
How do we word this to avoid the cases where the defense impugns the integrity of the victim, or if the victim is a member of an unpopular group, and so somebody might otherwise be guilty of assault or some serious crime against the person gets off just because the person who is the victim is unpopular. So
it's a reasonable, yeah, that's a reasonable concern. I personally am not too concerned that will actually happen, but if it did, that person's guilty verdict could be overturned on appeal. So I wouldn't worry about that. This jury nullification does act overall in the favor of defendants who are facing cases with really bad laws, like the marijuana laws, for instance, or the haircutting laws, as the sponsor testified.
Must you?
Very brief. Thank you, Chairman. You mentioned Judge O'Neill's use of the term conscience, and that's found in the Constitution, so this bill presumably would be constitutional.
Well, if you look at the Rich Paul verdict, the Supreme Court indicated that even if this language was what had passed originally, which obviously it wasn't, but even if this was what was the law today, that they may have decided that that was unconstitutional as well. So in my opinion, this bill doesn't go far enough. It's a step in the right direction, but the best thing to do would be to amend the Constitution to enshrine the right to jury nullification there.
Thank you very much.
Thanks.
I thought yours was the last card. One came in. Penny Gray.
Dean, I apologize for my bad hand.
Interpretation is couple meaning two.
Oh, that's a very good point. Yes, two meaning two.
And you support the bill?
I do support the bill, and if the committee doesn't like the language, I'm offering other language as an alternative that I have here to pass out to the committee. I was running a little late. My name is Penny Dean, for those of you who don't know me. I'm an attorney. I'm licensed in Maine, New Hampshire, Massachusetts, DC Circuit, and I do a fair amount of firearm and criminal work. And I think that we absolutely need something like this. And what we need, most importantly, whatever you choose, whether you choose my offering here or the language there, which I'm perfectly fine with, by the way. I'm not quibbling with the language. You need to use shall, that the judge shall instruct the jury. Because if you don't, we have unelected bureaucrats here that nobody at the polls next time can unelect them and make them accountable to the people. And so what you see happening are judges who won't give the instruction, and the chance of overturning that on appeal is very slim because the standard on review is abuse of discretion. And rarely does one judge find another judge abused his discretion. And so what I proposed as an alternative, and again, I'm not opposing this language, but if there are those in the committee that have concerns with it, if you go to the New Hampshire Bar's website, I always believe in hanging people with their own hard. And basically, they have a jury instruction there. It's instruction 3.17. And it says, even if you find that the state has proven each and every element of the offense charged beyond a reasonable doubt, you may still find the defendant not guilty if you have a conscientious feeling that a not guilty verdict would be a fair result in this case. And I think that's important, but I think what's more important is the language below it, which is the Bar Association's language, and I think it's important. It's the model jury instructions. However, the existence of the jury nullification power does not mean the jury must be informed by the judge of that power. And that's exactly how they perceive it. You don't even have to inform the jury. And I think this is really powerful when you look at their own words printed on their own website. Jury nullification is neither a right of the defendant nor a legal defense. And that's something that I strongly disagree with. Again, this is their words. The instruction on jury nullification may be one best given only when it's requested by the defendant or when the nature of a particular case otherwise warrants it. And again, you're asking a trial judge who's not elected in this state, unlike they are in most states, to determine whether or not that nullification instruction is allowed, and if so, the format it's going to be. And it says here very clearly, the trial court is vested with discretion to determine whether or not the facts of a particular case warrant such an instruction when it's been requested. And I think it's very important to know the thing that I do every time I have a case is I put myself in the shoes of the defendant. And I say, if it were me up there, if this was going to be the consequences to me, if this is what I was charged with and this is what I was facing, how would I want to be treated? Would I want this instruction given or not? And would I want it to be very clear that the judge cannot give another instruction than overriding this instruction? And I think that's what you have to really think about, because I can tell you that bureaucrats can play games. So you say, I got to do this, and they say, okay, and they give another contrary one. So I'm happy to answer questions about cases. I've requested jury nullification instructions, and the answer I get, to paraphrase, is tough noogies in many cases. And again, I just respectfully ask yourself each time to put yourself in the shoes of the defendant. And don't always believe what you read in the press, because the press is designed to sell papers, lots of them. And so the facts, if they're salacious.
Will you answer any questions?
Absolutely, I will. Yes, sir.
Representative Silvio?
Thank you, Mr. Chairman. Would you consider the defendant's right in this case as part of the right to due process? Is that involved in there? It's not really spelled out.
In my opinion, it is. I do not wear a black robe, but in my opinion, it absolutely is. And it goes back to put yourself in their shoes and read the Constitution. That is part of it. That's something our founding fathers spilled blood for.
Thank you, Representative Hopper.
Thank you, Mr. Chairman. So you have personally had cases in New Hampshire where you've wanted to inform the jury about their right to nullify, and you've been denied?
Yep. Not in so many words. They're going to give the Wentworth instruction. So they're going to say, well, we always give the Wentworth instruction. But I ask you, if it were you, would that be what you would want?
Yes.
Is that since we passed the law?
Not since you passed the law, but I've heard others who've had problems with it. Okay, so I've not had that problem since you passed the law. But I think the problem is it's kind of like the right to know law. You have to back it up with 10 times the amount of teeth you think you need to.
You have written testimony?
I have all this that I was preparing. I'll finish I was trying to staple quietly that I'll pass out. I brought 22 copies. Is that enough?
Yes.
I presume that, I did the math.
Thank you very much.
Thank you. Any other?
Okay. I will close the hearing on House Bill 4.
We'd like to invite you to visit freekeen.com. Freekeen.com features audio, video, and blogs chronicling the transition to a voluntary society. Freekeen.com also has comments and discussion forums so you can be heard. Freekeen.com.
I should be in Keene, New Hampshire with the Free Staters.